case involves the exemption status of service advisors at car dealerships. Service advisors are the employees who meet with customers to discuss servicing needs and to sell servicing solutions. The legal question that the court faced is whether service advisors count as salesmen primarily engaged in servicing automobiles. The court began by looking at the words of the statute and concluded that under a literal reading of the statute, service advisors are salesmen, they are primarily engaged in servicing, and as a result, they are exempt. The court then considered the reasoning that the Ninth Circuit used to reach a different outcome. The Ninth Circuit had used a rather arcane rule of interpreting statutes that under some circumstances allows a court to disregard the literal wording of the statute and instead to apply a different meaning. The court here said that the rule the Ninth Circuit used does not apply and that instead the strict literal reading of the statute should govern. The court then, in the most important part of the ruling, rejected the principle that statutes like the FLSA with its exemptions should be construed narrowly. Instead, the court said that the FLSA's exemptions should be given a fair reading, not a narrow reading, and as a result, the plain language governs and these employees are exempt. What the court did in Encino Motor Cars was to overturn about 73 years of its own precedent. Since 1945, in the decision A.H. Phillips against Walling, the Supreme Court had taken the view that the FLSA as humanitarian and remedial legislation should be construed in such a way that its exemptions from the overtime right would be construed narrowly, and that employees would be exempt only when they were plainly and unmistakably within the scope of an exemption. The court said that the principle of narrow construction is not a useful guide to interpreting the FLSA exemptions because the exemptions are just as much a part of the statute that Congress wrote as is the overtime requirement in the first place. And therefore, there was no principled basis for the court to assign more weight to the overtime right than to the exemptions, given that all of these parts of the statute are contained within the legislative compromise that gave rise to the FLSA. Most immediately, the ruling in Encino Motor Cars means that service advisors at retail auto establishments are exempt from the federal overtime requirement. There may still be issues under state law, but as most retail auto establishments have multiple service advisors, the ruling will affect the payroll at companies across the country in this industry. So this is a significant win for the retail auto industry. More generally, the abandonment of the narrow construction rule for FLSA exemptions means that for many workers in a variety of positions in industries throughout the economy, it will now be substantially easier for employers to demonstrate that those employees are exempt from overtime. So this is going to affect litigation throughout the economy.